There's a specific kind of laughter that never leaves you. Not the warm kind, the kind that fills a kitchen on a Sunday morning when someone tells a bad joke and coffee almost comes out your nose. I mean the other kind, the kind that has edges, the kind that is aimed at something or someone with surgical precision. And the person doing the laughing knows exactly what they are doing, even if they would never, in a million years, admit it. I heard that laughter on the morning of my 32nd birthday. It was a Tuesday, cold. The way early March in Pennsylvania tends to be cold. Not dramatically, not with a blizzard or anything cinematic, just relentlessly gray and damp. The kind of cold that sits in your joints and reminds you that winter is not finished with you yet. I had driven 40 minutes from my apartment in Harrisburg to the family home in Carlisle. Because my mother had called the week before and said with the particular brightness in her voice that she reserved for announcements she had already decided were going to go a certain way, that Grandpa Gerald had left something for me in his will. Grandpa Gerald, my mother's father. A man I had spent my childhood following around hardware stores and county clerk offices and dusty courthouse basements, listening to him explain property lines and deed records the way other grandfathers explained baseball statistics. A man who smelled like pipe tobacco and WD-40, and who had looked at me when I was maybe 9 years old and said completely seriously, "Marisol, you are the only person in this family who actually understands that land is not just dirt. It is time. It is recorded time." I had not fully understood that then. By my 32nd birthday, I understood it completely. I was a licensed real estate attorney with 6 years of practice under my belt, a specialty in property disputes and title insurance litigation, and a reputation in the Mid-Atlantic region for being, as one opposing counsel had once put it to a judge in a tone that was not entirely a compliment, exceptionally thorough. So I drove to Carlisle. I sat at the kitchen table. My mother, Diane, poured coffee and did not ask how I took it, even though she has known for 32 years that I take it black. My father, Robert, sat at the head of the table with the particular posture of a man who has already decided the outcome of the meeting he is in. And my brother, Derek, sat across from me and scrolled through his phone as though my arrival were a minor inconvenience in an otherwise productive morning. Derek is 4 years older than me. He has always been the one who got the bedroom with the window that faced the backyard. He got the car on his 16th birthday. He got the college tuition paid in full, while I received what my parents described as encouragement, and what I experienced as $18,000 in loans I spent 7 years paying off. Derek has a landscaping business that my father invested $30,000 in during its first year. Derek also has a habit of referring to my career as that law thing, as though I had taken up competitive knitting. My mother set a small cardboard box on the table in front of me. Inside the box, wrapped in a piece of cloth that had once been a dish towel, was a key. An old key, iron or something close to it, with a long shaft and a bow that had been worked into a simple circular shape. The kind of key you see in antique stores or on movie sets, meant to evoke Victorian drama. It was dark with age and lightly mottled with surface rust, the kind that coats but does not necessarily penetrate. It sat in my palm and it was heavier than it looked. My mother said Gerald wanted you to have it. There was a pause. And then she said, with exactly the tone I expected, "We are not sure what it opens." He was a little, toward the end. She made a gesture near her temple, a gentle, dismissive rotation of her fingers. My father cleared his throat and said he had a lot of old stuff. Boxes and boxes. You know how he was. And then Derek, without looking up from his phone, said, "Maybe it is the key to his heart," and laughed. My mother laughed. My father smiled, which for him is equivalent to laughing. That was the laughter. That was the specific kind I am telling you about. It was not loud. It was not cruel in any legally actionable way. It was just the laughter of people who have already sorted you into a category, who have decided years before this moment that you are the kind of person to whom old, useless things are given, while other people receive the real things. I looked at the key in my palm. I wrapped my fingers around it. I said, "Thank you." And I meant it, though not yet in the way they thought I meant it. Let me tell you about Gerald Hatch, because he deserves more than a gesture near someone's temple. He was born in 1941 in Cumberland County, Pennsylvania, the second son of a farmer who also happened to be something of a shrewd, largely self-educated property accumulator. Gerald's father, my great-grandfather Elias, had a philosophy that the family had apparently decided to find eccentric rather than instructive, which was that you should always own the ground under your own feet. Elias had spent 40 years buying small parcels of land in and around Carlisle whenever they became available, often for modest amounts, often at county tax auctions, often for properties that other people had looked at and decided were not worth the trouble. Gerald inherited this philosophy along with a portion of the parcels themselves when Elias died in 1978. Gerald was also given, along with his brother Thomas and his sister Ruth, a share of whatever the estate consisted of at that time. But here's the thing about Gerald, and the thing I came to understand gradually over years of Saturday afternoons in courthouse basements: he never stopped. While his brother Thomas sold his inherited parcels within a decade to fund a restaurant that failed, and while his sister Ruth converted hers into modest residential lots and sold those too, Gerald kept his. And then he bought more. Not flashy purchases. Not the kind of real estate that gets written up anywhere. Gerald bought easements and mineral rights and small commercial strips in places that people had not yet decided were going to matter. He bought a row of storage units on the edge of town in 1989 when self-storage was considered a novelty. He bought a strip of commercial property along a state road in 1994 when the state road was considered secondary. He kept meticulous records. He filed everything correctly. He paid his taxes on time every time because he understood, as he once told me while we were walking through the Cumberland County Recorder of Deeds office, that the only thing standing between a landowner and losing everything is a correctly filed document. He taught me to read deed books. He taught me what a chain of title meant. He taught me to look at a tax map not as a picture but as a narrative, a story of who had owned what and when and why it had changed hands, and whether those changes had been recorded properly. My mother thought he was taking me to these places because he had no one else to take. She found it faintly embarrassing, the way that some people find any serious engagement with the actual mechanics of money and property faintly embarrassing, as though being interested in how wealth actually works is somehow less refined than simply having it or wanting it. She had no idea what he was actually doing with me in those basements and offices and record rooms. She had no idea what he was teaching me to look for. And neither, for a long time, did I. I drove back to Harrisburg with the key on my passenger seat. I have a partner, Luce, who is a forensic accountant and who has what I can only describe as a preternatural ability to look at a pile of documents and identify the one number that does not belong. She was at our kitchen table when I got home, working through something on her laptop, and she looked up and said, "How was it?" I put the key on the table between us. She looked at it for a moment and said, "That is either very meaningful or very weird." I said, "I think it is both." Then I said, "He left me a key, Luz. Gerald left me a key. Not a document, not a letter, not a verbal instruction through an attorney. Just a key, which means there is a lock. And if Gerald Hatch put a key in his will and had it delivered through an attorney's office, then whatever that key opens is not nothing." She looked at the key again, and then she looked at me the way she looks at a spreadsheet when she suspects it has been manipulated, careful, interested, without any of the noise that people add when they want to seem empathetic but are actually just performing concern. She said, "So where do we start?" We started with the probate filing. Gerald Hatch had died 11 weeks earlier in January at the age of 82, of congestive heart failure in the house he had lived in for 40 years. He had been under the care of a home health aide in his final months, and he had, according to the official probate record, left a will that had been executed in the presence of 2 witnesses and a notary on September 14th of the previous year, which was, I calculated quickly, exactly 6 months before he died, and approximately 3 weeks after I'd visited him for what turned out to be one of our last real conversations. The probate record was public. I pulled it the same evening I got home, sitting at our kitchen table with the key 6 inches from my left hand. The will, as filed, listed the following: Gerald Hatch's primary residence and the 2 acres it sat on, to be divided equally among his 3 surviving children, meaning my mother Diane and her 2 siblings. His savings accounts, totaling slightly under $40,000, split equally 3 ways. His vehicle, a 2009 pickup truck, to his son Martin, who was my mother's younger brother. A collection of tools and equipment to be distributed at the family's discretion, and one item described in the will as the iron key currently held by the law office of Perkins and Associates in Carlisle, Pennsylvania, to be given to his granddaughter Marisol Vega upon the reading of the will. That was the entirety of the bequest to me, a key. But here's what I noticed, and what made Luce lean forward when I read it to her. There was no schedule of real property attached to the will. In a proper estate filing, when the deceased owned real property, land, buildings, commercial parcels, anything with a deed, those properties are listed in a schedule that attaches to the will. They are itemized. Their assessed values are noted. The chain of title from the deceased to the beneficiaries is established through the probate process. Gerald Hatch had spent decades acquiring real property throughout Cumberland County, and the probate filing contained no such schedule. Luz said quietly, "Either he sold everything before he died, or," I said, she finished the sentence, "or the estate is not complete." The next morning, I was at the Cumberland County Recorder of Deeds office when it opened at 8:30. I know that office the way I know my own apartment. I know which clerks prefer to be approached with a specific request already written down versus which ones prefer a conversational lead-in. I know where the deed books are kept for each decade going back to the 19th century, and I know how the digital records are indexed and what their limitations are. I spent 4 hours there that first morning, and then I went back the next day and the day after that. What I found over those 3 days was this. Gerald Hatch had owned, at various points in the past 4 decades, 23 distinct parcels of real property in Cumberland County. Between 2019 and the year of his death, 19 of those 23 parcels had been transferred by deed to various entities. Some had been sold to third parties. 4, however, had been transferred by quitclaim deed to a limited liability company called GH Properties LLC, formed in Pennsylvania on March 3, 2021. A quitclaim deed, for anyone who is not a property attorney, transfers whatever interest the grantor has in a property without making any warranties about that interest. They are fast, they are simple, and they are often used in family transactions precisely because they do not require the rigorous title examination of a warranty deed. They are also, in the wrong hands, a mechanism for moving property in ways that are difficult to immediately track. GH Properties LLC. I ran the Pennsylvania business entity search. The registered agent was listed as a law office in York, Pennsylvania. The members of the LLC were not publicly listed, because Pennsylvania does not require disclosure of LLC members in the formation documents. However, the registered agent's filing included an organizer's signature, and the organizer of GH Properties LLC was listed as Derek Allen Hatch. My brother. I sat in my car in the parking lot of the county recorder's office, and I did not move for approximately 4 minutes. I have developed, over 6 years of practicing law, a fairly reliable internal system for managing moments when evidence lands in a way that is simultaneously surprising and completely logical, when you realize you already knew something without knowing you knew it. This was one of those moments. Derek had organized an LLC in 2021 in Gerald's name, or using Gerald's initials, and 4 parcels of Gerald's property had been transferred into that LLC by quitclaim deed between 2021 and 2022. The LLC membership structure was opaque. Gerald had executed those deeds, his signature was on them, they had been notarized, they were correctly filed. But Gerald at that time had been 80 years old and experiencing the early stages of the cognitive decline that my mother had so delicately referenced with the gesture near her temple. And the transfers had not appeared anywhere in the probate filing, because if GH Properties LLC owned the property, then Gerald no longer owned it at his death, and therefore it did not need to be disclosed in the estate. I called Luz from the parking lot. I told her what I had found. She was quiet for a moment, and then she said, "Send me the LLC filing date and the deed transfer dates and the assessed values of the 4 parcels." I sent them. 20 minutes later, she called me back. She said, "Marisol, the 4 parcels together have a current assessed value of approximately $840,000. I want you to hear that number clearly." I heard it clearly, she said, "and based on the tax records I am looking at, 2 of them are currently generating rental income through commercial leases." I need to tell you about those 4 parcels because they are not abstract. They are specific places that I had visited with Gerald, that I had helped him think about, that I knew from the deed books and the tax maps, the way I knew the rooms of my childhood home. The first was a strip of commercial property on State Route 11, about 2 miles outside of Carlisle proper. In 1994, when Gerald bought it, it had a small auto repair shop on it that was barely breaking even. By the early 2010s, the state route had developed significantly, and the parcel had been subdivided into 3 commercial bays, 2 of which were leased to a regional dry cleaning chain and a dental office. Combined lease income, based on the county tax records and the commercial lease filings I eventually obtained, approximately $68,000 per year. The second parcel was the storage facility, the one Gerald had bought in 1989 when self-storage was a novelty. It had been expanded twice. It now had 112 units at varying sizes. Average occupancy rate in Cumberland County for self-storage, based on industry data I pulled, 83%. At standard market rates for that area, I estimated annual gross revenue somewhere between $200,000 and $250,000. The third parcel was a small commercial building in downtown Carlisle that had, at various times, housed a print shop, a tax preparation office, and most recently a physical therapy practice that had been operating there for 6 years under a long-term lease. The fourth parcel was the one that made everything click into a different shape entirely. It was a residential and light commercial mixed-use property. It was the building that my parents had lived in for 21 years. My parents did not own their home. I had always understood them to be homeowners. They had always referred to the house as their house, used the possessive with total ease and conviction, had never in my memory discussed rent or lease payments or a landlord. But when I pulled the deed record for that address, the chain of title was clear. Gerald had purchased the property in 1997, Gerald had always held title, and in January of 2022, Gerald had transferred title by quitclaim deed to GH Properties LLC, organized by my brother Derek. My parents, my father and my mother, Diane and Robert Vasquez, were tenants, and my brother Derek was, through the LLC, their landlord, whether they knew it or not. I want to be precise about what I did next because this matters. I did not call my family. I did not send an angry text. I did not draft a letter to Derek or call my mother and ask pointed questions. I have learned through years of litigation that the most important thing you can do when you have a significant discovery is to stop and organize before you act, because information without structure is just noise, and noise does not win cases. I called my attorney contact at Perkins & Associates, the firm that had handled Gerald's will. His name is Dennis Perkins, and he had handled Gerald's legal affairs for approximately 15 years. I told him I had some questions about the estate filing and asked if we could meet. He was careful on the phone in the way that attorneys are careful when they suspect a conversation might become adversarial. He agreed to meet. In the meantime, Luz and I spent 4 days building what we came to call the property map. We traced every deed. We identified every transfer. We pulled the LLC articles of organization, the registered agent filings, the annual reports. We obtained the tax assessment records for each of the 4 parcels. We pulled the commercial lease filings from the county. We identified the dates of each quitclaim transfer relative to Gerald's documented medical history, which I obtained through a careful request to his home health aid agency, framed as a family inquiry related to the estate. Gerald had been formally diagnosed with mild to moderate cognitive impairment in March of 2020. The first quitclaim deed transferring property to GH Properties LLC was executed in October of 2021, 18 months after that diagnosis. The deed was witnessed and notarized, but Gerald's capacity at that time was, at minimum, questionable. And there were 4 deeds total, all executed between October 2021 and February 2022, all transferring to the same LLC, all organized by my brother. I also very quietly called the physical therapy practice in the downtown Carlisle building to confirm they were still operating under a lease. The receptionist said yes, they had renewed for another 3 years. I asked gently if they could tell me who their landlord of record was. She said she would have to check and put me on hold. And when she came back, she said the lease was with GH Properties LLC, managed through a property management company in York. Then I called the dry cleaning chain's regional office and asked the same question. Same answer. Same LLC. I sat with all of this information for approximately 48 hours before I made any move. I wanted to be sure I was not only right, but demonstrably, documentably, irrefutably right. Because there is a difference between knowing something and being able to prove it in a way that leaves no room for alternative interpretation. Gerald had taught me that in the deed offices, the document matters. The recorded document matters. My meeting with Dennis Perkins took place on a Wednesday afternoon, 9 days after my birthday. His office was on the second floor of a brick building on High Street in Carlisle, the kind of office that has been practicing law in the same location for so long that it has accumulated a specific smell of old paper and central heating and institutional quiet. I laid out what I had found, methodically, with the documents organized in a folder I'd prepared the way I prepare materials for depositions. Sequentially, clearly labeled, with a one-page summary at the front. Perkins is a man in his mid-60s who has the measured, unhurried manner of someone who has seen most things and has learned not to show his reactions until he has had time to process them. He read through the summary. He examined the deed copies. He looked at the LLC formation documents. And then he set everything down very carefully on his desk, and he was quiet for a moment. He said, "I need to tell you something," and he said it with the tone of a man who has been wondering when this conversation was going to happen. He told me that when Gerald had come to him in September of the previous year to execute the will, Gerald had also given him something to hold. Not a document, an object. And a letter sealed, addressed to Marisol Vega, to be opened in the event that certain questions arose regarding the estate. The object was a second key, not identical to the one I had been given, but the same age, the same type. A pair. The letter, which Perkins gave me with the formal gravity of a man who understood he was handing over a significant piece of information, was 4 pages long, handwritten in Gerald's careful, slightly compressed script, with occasional shakiness in the letters that told me it had been written by a man whose hands were not entirely reliable anymore, but whose mind, in that moment, had been as precise as it had ever been. I read the letter in Perkins' office. I will tell you what it said, not word for word, but its substance, because Gerald's words were his and I hold them privately. But their meaning belongs to this story. Gerald knew what Derek had done. More than that, Gerald had allowed it to appear to happen, because he had needed to understand the extent of what Derek was willing to do. He had, over the 18 months during which the quitclaim deeds were executed, been less cognitively impaired than he had allowed anyone to believe. He had remained sharp enough to make deliberate decisions, and he had made one. The 4 parcels transferred to GH Properties LLC had not been transferred to Derek as a gift or as a legitimate estate planning maneuver. They had been transferred under duress, with Derek present at the notarizations, with documents that Gerald had signed while Derek had made clear, in ways that Gerald described in the letter with quiet specificity, that Gerald's ongoing care and comfort in his final years was connected to his cooperation. Not a threat, not anything Gerald could have easily characterized to a stranger. Just an understanding, a pressure, the kind that happens in families and leaves no marks. But Gerald had prepared. He had spent a year and a half preparing, and the key was the center of it. The 2 keys were to a safe deposit box at a branch of a regional bank in Carlisle, a box that required 2 keys to open, both of which had to be present simultaneously. One key had been given to me through the will, the other had been held by Perkins. In the safe deposit box, Gerald had placed the following: a complete inventory of all his property holdings, as of August of the previous year, copies of all 4 quitclaim deeds, a signed, notarized affidavit in which Gerald described the circumstances under which each deed had been executed, including Derek's presence, the language Derek had used, and Gerald's assessment of the pressure involved. A separate signed statement from Gerald attesting to his cognitive state at the time of each signing and his belief that his judgment had been compromised not by dementia, but by a deliberate and sustained campaign of coercion by his grandson. A copy of a second will validly executed, dated 1 week before the first, which left the entirety of GH Properties LLC, through a mechanism Gerald's York-based business attorney had constructed, to a trust of which I, Marisol Vega, was the sole trustee and beneficiary. and a letter to me. That 4-page letter. The last paragraph of that letter I will give you almost exactly as he wrote it. He wrote, "Marisol, you are the only one who went into those basements with me. You are the only one who understood that documents are not just paper. They are promises that have been made in front of witnesses. I am leaving you a mess. I am sorry for that. But I'm also leaving you everything you need to clean it up. You know how. You taught yourself. I just showed you where to look." I opened the safe deposit box the next morning, with Perkins present as a witness, with Luce beside me, with a video recording of the opening made on my phone. The contents were exactly as the letter described. Every document was there. The affidavit, 8 pages, notarized. The second will, properly executed. The inventory, the deed copies. I sat in the small private room they give you in banks for safe deposit box access, and I went through each document with the same careful attention I bring to discovery files in major litigation, which is what this now was. Then I went back to my apartment in Harrisburg and Luce, and I spent 6 days preparing the challenge to the GH Properties LLC structure, the challenge to the quitclaim deeds based on undue influence in Gerald's documented cognitive state, the submission of the second will to the Cumberland County Orphans Court for probate, and a formal complaint to the Pennsylvania Office of Attorney General's Elder Financial Abuse Unit. I want to be clear about something. This was not revenge. I know that word is available here, and I am declining it deliberately. What I was doing was what Gerald had asked me to do. I was correcting a series of fraudulent property transfers, establishing the legitimate chain of title, and protecting an estate from a person who had exploited an elderly man's declining health for financial gain. That is not revenge. That is exactly what I was trained to do. It is what Gerald had always believed I would be capable of doing, which is why he had spent 32 years of my life teaching me to do it. I filed everything on a Monday. By Wednesday, Derek had received notice of the challenge to the quitclaim deeds and the competing will submission. By Thursday, the elder financial abuse complaint had generated a response from the AG's office indicating they were opening an inquiry. By Friday, the property management company in York that was managing the commercial leases on behalf of GH Properties LLC had received notice that the LLC's authority over those properties was subject to a pending legal challenge. My mother called me on Friday evening. She said, "Marisol, what is happening?" It was not a question. It was the specific inflection of someone who already knows what is happening and is calling to confirm that it is as bad as they think. I said, "Mom, I have filed documents in the Orphans Court challenging 4 property transfers that I believe were made under undue influence on Grandpa Gerald in the final years of his life. I have also submitted a second will for probate that Gerald executed and placed in safekeeping. I am happy to walk you through the specifics if you would like." There was a silence that lasted long enough for me to count my own heartbeats. She said, "Derek told us he was helping Gerald with his finances." I said, "I know." She said, "He told us the LLC was for tax purposes." I said, "I know, Mom." She said, "Marisol, your grandfather always had a soft spot for you. This does not mean you get to upend the whole family over a sentimental old man's last wishes. I want you to understand the specific architecture of that sentence. I want you to hear the way it worked. It simultaneously minimized Gerald, dismissed his legal documents as sentimentality, and framed my filing of properly executed legal instruments in the appropriate court as some kind of emotional overreach on my part. It was, in its way, a perfectly designed statement. It assumed that I could be managed by the same framing that had managed me my entire childhood. I said, "Mom, I would encourage you and Dad to consult an attorney, not Derek's attorney, an independent one, because there is something specific about your situation that you need to understand." She said, "What are you talking about?" I said, "The house you are living in, the property at your address. It was transferred to GH Properties LLC in January of 2022. That means you and Dad are tenants. Your landlord technically is the LLC, which means that if the court upholds the quitclaim transfers, Derek controls your housing. And if the court invalidates the transfers and the second will is accepted, then your housing situation will be determined by the trust I administer." Another silence. This one different. Longer. She said, "That cannot be right." I said, "Mom, I am a property attorney. It is right." I pulled the deed myself. The hearing in the Cumberland County Orphans Court was scheduled for 6 weeks after my initial filing. In those 6 weeks, several things happened in rapid succession. Derek retained an attorney, a man from Harrisburg who specialized in estate litigation and who filed an immediate challenge to the admissibility of Gerald's affidavit on the basis that Gerald's cognitive state had been impaired at the time it was executed. This was, I have to say, a bold strategy, given that the entire foundation of that argument required proving that Gerald had been impaired enough to invalidate his own testimony about being coerced, while simultaneously arguing that he had been competent enough to validly execute the quitclaim deeds that transferred property to Derek's LLC. You cannot have both. You cannot argue that a man was too impaired to write a credible affidavit and simultaneously argue that the same man was fully competent when he signed the deeds that benefited you. Derek's attorney was good enough to understand this too, and within 2 weeks, the cognitive incapacity argument had been quietly replaced with an argument that the second will was invalid on technical grounds. It was not invalid on technical grounds. I had reviewed it 3 times before filing it. Gerald's York attorney, who had prepared it and witnessed its execution, was a meticulous practitioner, and she had done everything correctly. The technical challenge went nowhere. The Elder Financial Abuse Inquiry from the AG's office was proceeding on a parallel track, and while I was not a party to that investigation, I was a cooperating witness, and I provided them with the same documentation I had filed in the court proceedings. My parents retained an attorney, as I had suggested, and that attorney, after reviewing the deed history for their property, had what I imagined was a very frank conversation with them about their actual legal situation. I know this because my mother called me again, approximately 3 weeks after the first call, and this time her voice was different. The managed brightness was gone. She sounded like someone who has had something explained to them that they genuinely could not believe was true and has now run out of ways to disbelieve it. She said, "Our attorney says we have been renting from Gerald this whole time and we did not know it." I said, "That is correct. Gerald never transferred the property to you and Dad. He held title until the LLC transfer." She said, "Why did we not know this?" And this was the question I had been expecting and dreading, because the answer to it opened a much larger and more uncomfortable room. The answer was, because no one in the family had ever looked, because my parents had assumed they owned their home without verifying the deed, because the assumption of ownership had been sufficient for them, and they had never, in 21 years of living in that house, paid enough attention to the actual documentary record to discover what was really true. I said, "Mom, you should be able to verify the deed status at the county recorder's office. It is public record. It has always been public record." She did not say anything. I said, "I am not going to make this worse. I want you to know that whatever happens with the court proceedings, my intention with the trust is to ensure that you and Dad have secure housing. I will not use this as leverage against you. But I need you to also understand what Derek did, and I need you to stop treating what I have filed as an attack on the family." She said, "He told us he was helping." I said, "I know. That is what this kind of thing always looks like." The orphans' court hearing was held on a Thursday morning in late May. The courtroom was not large. These proceedings rarely have the drama that people imagine courtrooms to have. There was a judge, a woman in her mid-50s, with the particular manner of a jurist who reads documents with complete attention and asks questions that are precise and moderately deadly to the unprepared. There were attorneys for both sides. There were affidavits submitted into evidence and copies of deeds and the corporate filings for GH Properties LLC. There were medical records related to Gerald's cognitive assessment, provided by his former physician, who had submitted a written statement that Gerald, while experiencing early-stage impairment, had retained sufficient decisional capacity during periods of clarity, and that the affidavit Gerald had executed with Perkins was consistent in its tone and content with the Gerald Hatch the physician had known for 12 years. Derek was present. He sat at the respondent's table in a gray suit that looked recently purchased and looked at the papers in front of him more than he looked at anything else. We did not speak. I had nothing to say to him that was not already in the documents. The hearing was not a trial. It was a proceeding before the court to determine whether the second will should be accepted for probate and whether the quitclaim deed transfers should be referred to further proceedings on the undue influence question. Both of those questions were resolved in my favor that day. The judge accepted the second will for probate, finding that it met all formal requirements and that there was sufficient evidence to warrant its consideration. She referred the undue influence question to a full evidentiary hearing. The evidentiary hearing was 4 months later, and it was longer and more detailed and involved testimony from Gerald's home health aide, from his physician, from Dennis Perkins, from me, and from Derek. It also involved testimony from the notary who had witnessed 2 of the quitclaim deeds, who confirmed under oath that Derek had been present for both signings and had spoken for Gerald on several points when Gerald had appeared to lose his place in the documents. The court found, after deliberation, that the 4 quitclaim deed transfers from Gerald Hatch to GH Properties LLC had been effected through undue influence and were void. The properties reverted to Gerald's estate. The second will was accepted as the governing instrument. GH Properties LLC was left with no assets and was dissolved by Derek within 30 days of the ruling. The AG's elder financial abuse inquiry resulted in Derek entering into a civil settlement agreement, the terms of which are not public, but the existence of which is a matter of record. He did not face criminal charges. The standard for criminal elder financial abuse in Pennsylvania is high, and the evidence, while compelling, was determined by the AG's office not to meet the threshold for prosecution. I was not the decision-maker there. I provided what I had, and I accepted the outcome. I became the trustee of the Gerald Hatch Property Trust. The 4 parcels, valued collectively at approximately $840,000 in assessed value and generating annual income from commercial leases of approximately $312,000 gross, came under my administration. On a Tuesday morning in late September, exactly 6 months and 1 week after my birthday, I sat at a desk in a small administrative office I'd set up in Carlisle and signed the documents that established the trust's formal authority over the properties. The commercial leases were transferred to the trust. The storage facility's management agreement was updated. The residential property at my parents' address, the house they had lived in for 21 years, was now managed by my trust. Their rent, for the record, remained exactly what it had been. I did not raise it. I sent them a formal lease agreement because they needed one, and I set the rent at a number I knew they could manage. And I included a clause that gave them right of first refusal if the property was ever put on the market. I did this not as a gesture of power and not as an act of generosity. I did it because it was the correct administrative decision and because Gerald would have done it. I want to talk about the laughter. I have thought about it many times since that Tuesday morning in March when I drove home with a rusty key on my passenger seat. I have tried to understand it not as a wound but as information, because wounds invite drama and information invites analysis, and analysis is more useful. The laughter on my birthday told me several things. It told me that my family had made a consistent, long-term decision about who I was and what I was capable of, and that this decision was not going to be revised based on evidence. It told me that the key, in their estimation, was the measure of what I was worth to Gerald. Not money, not property, not something real, but a curiosity, an old thing, a gesture from a slightly diminished old man to his slightly overlooked granddaughter. What the laughter could not tell me, because the people laughing did not know, was that Gerald had spent decades building something and had spent the last years of his life ensuring that it was protected, and that the protection mechanism he had chosen was me. Not because I was his favorite in some sentimental sense, because he had watched me learn to read deed books, because he had watched me understand what a chain of title meant, because he had trusted me with the actual mechanics of how real things work, and he had known that when the time came, I would know what to do with them. The key was not a slight, it was an instrument. It was the beginning of a process that my family's laughter had made invisible to itself. Derek and I have not spoken since the evidentiary hearing. I do not expect that to change. I am not holding that door open and I am not nailing it shut. I have simply established a boundary that I did not have the leverage or the clarity to establish before, and I am holding it without hostility and without negotiation. He made decisions and those decisions have consequences, and I am not responsible for managing his relationship to those consequences. My parents are more complicated. They are people who believed what they were told by someone they trusted and who were wrong, and who are now living in a house managed by a daughter they had sorted into the category of the slightly irrelevant. I have not punished them for that sorting, and I do not intend to. But I have also not pretended it did not happen, and I have not accepted the framing that my actions were the disruption to the family, as opposed to the disruption being the years of fraudulent maneuvering that preceded them. My mother called me in October, after everything was settled. She said, "I want you to know I am proud of you." She said it with sincerity, or at least with something that had the shape of sincerity. I said, "Thank you, Mom," and I left it there. I did not say, "You laughed at the key." I did not say, "You called Gerald sentimental when he was in the ground 2 months." I did not say, "You have been proud of Derek for 25 years, and the one thing you can cite as evidence of that pride is $30,000 that went into a business that mostly breaks even." I said, "Thank you." And then I said, "I need to go. I have a meeting." And I did. The storage facility is on a quiet stretch of road that I drove past dozens of times as a child without ever giving it much thought. It is not beautiful. It is a series of corrugated metal structures with roll-up doors and a chain-link perimeter, and a small office at the front with a code-activated gate. It generates, on a good month, somewhere between $18,000 and $20,000 after expenses. It will not always generate that. Markets change, demand shifts, properties require management and maintenance and ongoing attention. But it is there. It is recorded. It is mine to administer and trust for the purposes Gerald established, which included, in the trust document, a specific designation of income allocation that sets aside a percentage for property maintenance, a percentage for potential reinvestment in additional property, and a percentage to be used at the trustee's discretion for purposes consistent with the grantor's values. Gerald's values, as I understood them and as the trust document reflected them, were maintain what you own, improve what you can, record everything correctly, and never assume that what you have is secure simply because you have always had it. Security is a document. Security is a correctly filed document in the right office with the right signatures. I have a framed copy of the first deed I ever learned to read, in Gerald's deed book from 1989, in my office in Harrisburg. It is not decorative. It is a reminder. The world runs on documents that most people never bother to look at, and the people who understand those documents have an advantage that is quiet and deep and, in the right circumstances, absolute. There is a specific kind of laughter that never leaves you. This is true. It stays with you. But what also stays with you, and what that laughter could not predict, is what you do with the thing they are laughing at. The key was heavy in my hand on that cold March morning. It was heavier than it looked. Everything that mattered was heavier than it looked. Luce asked me, the evening after the trust was formally established, how I felt. Not about the property or the legal outcome or Derek or my parents, about the whole of it. About where I was now versus where I had been on my birthday. I thought about it for a moment. Then I said, "I feel like the document is correctly filed." She laughed, but not the other kind. And I laughed too. And we went back to work. If you are someone who has been given the old things, the dusty things, the overlooked and seemingly useless things, by someone who understood more than they were given credit for, look more carefully. The value that matters is rarely the value that is immediately visible. It is in the record. It is in the chain of title. It is in what has been carefully, quietly, and deliberately preserved for the person who knows how to receive it. Gerald Hatch spent 40 years building something. He spent 18 months watching it be threatened. And he spent what was left of his time on Earth making certain that the right person had everything they needed to protect it. I was the right person. Not because I was the most loved or the most visible or the most celebrated, because I was the one who went into the basements. Because I was the one who listened. Because when he pointed at a deed book and said, "This is recorded time," I understood what he meant. The rust on the key was surface only. Underneath it was solid iron, and it opened exactly what it was made to open. That is the whole of it. That is enough.